Hello everybody. If you're preparing for exams, I hope your revision's going very well. Here's a bit of help. Well, I hope it's of help. How to answer a question on designs. As usual, the question comes from a University of London International Programme exam paper. It's the 2017 paper. The University of London syllabus doesn't include registered designs, so it's a bit artificial. And it may be that if you're not doing that course, you need to know something slightly different. But even so, this ought to help. As always, I'm not going to risk infringing the university's copyright by setting out the question exactly. The important facts seem to be that we have a wedding dress made by B, that's Blanc Ltd, designed by Ursula, U, who conceived the idea, those are the words used in the exam, while she was working for Blanc. I think that's a bit of a red herring because nothing else in the exam requires you to consider the important dichotomy between ideas and expressions in copyright law, or indeed in design right law. So she conceived the idea while she was working for Blanc. She then went on to make a design based on a painting, a 19th century painting which she saw in a gallery in London. It doesn't say when she saw it, but presumably that was all tied up with her conceiving the idea. Then we have the intervention of another person, Victor, who is the pattern cutter, and the dress which is made by Blanc is worn by Roberta. These questions have a cast of thousands. Roberta is enough of a celebrity for her wedding to be shown on television, so everybody in the world has seen the dress. Well, perhaps not everybody, but it's been widely seen. Gris is producing cheap knockoffs, and Noir is producing copies. I don't know whether the examiner intended by calling them Gris and Noir to tell you something about the seriousness of what they were doing, but I think whether the goods they were making were grey or black is immaterial. So those are the facts. Now let's look at the question. You're asked to advise Wanda, who's the managing director of Blanc, about possible claims under the Copyright Designs and Patents Act 1988. Presumably this means claims against Gris and Noir, because you don't know about anybody else that claims might lie against. But I do sometimes wish the examiner would tell you expressly. So reading through the question, you probably already concluded that trademarks and patents are going to have nothing to do with this. But when the examiner tells you to advise under the Copyright Designs and Patents Act, you know that copyright and design right could both be engaged. The London examiner certainly likes to put them both into the questions. When I set exams, I like to do that as well. I bet a lot of other examiners do too. As far as design rights concerned, we're going to be thinking about the scope of design protection and whether it's going to extend to certain features like the air blowers. Are they methods and principles of construction? What about the protection of surface decoration? Copyright may also be involved. Are there graphic works, drawings, surface decoration? Is there possibly a work of artistic craftsmanship? And will we have to think about Section 51? Well, I can tell you now that the examiner is always going to include Section 51 in one of these questions. So the answer to that is yes, inevitably. Let me just tell you a little more about why the examiner sets problem questions in this area. As I said, they always involve copyright as well as design right. It's worth checking, because it would be just my luck if the examiner decided next year to do it exclusively about design right, but I think you should start with the presumption that it's going to have them both involved. And the examiner sets problems on designs with a view to finding out about what you know in two areas. First of all, about qualification for protection under Part 3, design right. If you look back through the old examination questions, the designer is never an EU citizen. He or she is Japanese or Mexican or Australian or American. So that means you're going to have to drill down into the rules about qualification in order to find the one that fits the case. It's not the obvious answer. And secondly, the examiner is going to be asking you about Section 51, which is in the copyright part of the legislation. It's a permitted act that applies where the copyright work in question is a design document, unless, importantly, the design is for an artistic work. And again, spoiler alert, there's always going to be the possibility that the design will be for an artistic work, as is the case in this question. Design questions are issue heavy. You've got to identify the issues and you've got to set out the law. There won't be much scope for giving firm answers about which way things are going to fall, and that's not the purpose of the exam anyway. Don't speculate too much about how it's going to turn out, because you won't have time for it. These questions are huge. But I like the fact that they're finite. All the facts are there. You can identify the issues, work your way through them, and you know when you finish the question. And I also like the fact that you can pick up a lot of marks pretty quickly and easily. There's a lot of low-hanging fruit. And if you're under time pressure because of the other questions that you've answered in the exam, it's quite useful to be able to whiz through a question like this quite quickly and get a lot of the marks that are available in the bank, even if you don't have the time to write a complete answer. Like many questions, and particularly problem questions, the examiner plants a lot of signposts in the question, so let's just have a look at some of those. You read through the question, you discover that Ursula is American, so you know that qualification is going to be an issue, qualification for protection under design right, and you also have to mention qualification for protection under copyright, although that's not going to be a complicated one. You'll read also that she was a placement student. Does that mean she was an employee? Probably. Does it mean that she created designs in the course of her employment, which is much the more important question? That seems pretty unlikely. The question refers to ideas. Is that relevant? She makes her sketches from a 19th century painting. So is her work going to be original at all? She made sketches which are copyright artistic works. So you know that while design right is obviously going to be an important part of this, copyright is going to be engaged as well. The dress was handmade. That signpost points you in the direction of it being a work of artistic craftsmanship for copyright purposes. And you're also told that the pattern was cut by Victor. So probably he's going to make an appearance somewhere in the answer as well. There's embroidery on the dress, which is surface decoration. So you need to think about how that's going to be protected. And the blowers, will they be protected as part of the design? You've also got the integral gloves that you need to think about, but there is no doubt that they are clearly part of the article. So we should begin by considering qualification for design right. I think approaching this question in any other way than keeping design right and copyright pretty much separate would be a mistake. It would be very easy to get into trouble. And for both rights, you've got to start by considering qualification, because without qualification there's absolutely nothing to argue about. Of course, the examiner won't let you off that lightly. There's never going to be a problem question where you can say, well, it doesn't qualify for protection at all, therefore I'm going to move on to the next question. You're going to give me full marks for that, aren't you? Sadly, life isn't like that. So here, you're going to have to go through the rules on qualification for design right. And as I've already said, that's one of the primary reasons that the examiner set this question in the first place. And you've got to work through these rules in sequence. First thing to ask is whether Ursula qualifies for protection. And the first part of this answer is quite easy, because she's American. So by nationality, no, she doesn't qualify. She'd have to be an EU citizen, or actually a citizen of another country or territory which gives reciprocal protection to UK designs, of which the only significant example is New Zealand, and mercifully the examiner's never asked a question about a New Zealand designer. So that's a fairly easy mark or two to get, pointing out to the examiner that Ursula is not going to qualify by reference to her nationality. I think incidentally the examiner has made this part of the question far more complicated than they realised. So the next part of your answer is to say that she could qualify for protection by habitual residence in the European Union. The problem with this is you haven't got any facts to go on, so all you can do is raise that as a possibility, perhaps supported by reference to the fact that she was working for Blanc, and was visiting art galleries in London. So it looks a bit like she was resident somewhere in the UK, probably in London, but whether that amounts to habitual residence is another matter altogether. So tell the examiner you know that, and you've got some more marks. But it might not matter. It might not matter because she might have been employed by a European Union employer, in which case section 219 might apply. Notice this is the first section number I've mentioned here. I've been assuming that you're familiar enough with the provisions of the statute for me not to have to tell you up to now, and I don't think you're going to get very far really by throwing in section numbers in the exam, but I've given you this one because you might want to go and look at it. So if the design was created in the course of her employment, it might qualify for protection by reference to the employer. So as far as I know, the only EU countries where you have companies with the word limited at the end are the UK and Ireland. I guess Malta and Cyprus might have a similar approach, but I think you'd be on fairly safe ground assuming that Blanc Ltd is British, or at least, or if not British, either Irish, and if she created the work in the design in the course of her employment, it would be protected, it would qualify for protection by reference to the employer. But that's a big question. Did she make the design in the course of her employment? Are placement students expected to originate designs? Doesn't sound to me as if that was the purpose for which she was employed. Indeed, I go further than that, although you won't need to in the exam. But if they were expecting placement students to produce very expensive wedding dress designs, that's highly immoral. So you move on to the third way in which it might qualify for protection, and say if articles made to the design are first marketed in the European Union, then it'll get protection that way. So I think we've got two possibilities here. First of all, that she's habitually resident somewhere in the European Union, probably the UK and probably London, and failing that, first marketing would seem to be the solution. But I think this is a case where the examiner is going to need to see that you understand the whole of this qualification issue. As I say, I'm not entirely convinced that the examiner realised how complicated this was. And it gets worse because the answers to these questions have a bearing on the ownership of design right. And when you come to consider ownership, both of design right and of copyright, remember what the examiner's instructions to you were. You've got to advise Wanda, the managing director of Blanc Ltd. It says that you've got to advise about claims, but the way to approach it might be, depending on how all these things pan out, to say to Wanda, you've got no claims at all unless you collect in some of these rights and put yourself in a position to sue. You need to get assignments from Ursula and possibly also from Victor. Anyway, I'm jumping ahead a little there. Who owns design rights? Well, it does sound as if Ursula was employed by Blanc. If she made the design in the course of her employment, then Blanc owns the design right. So if that's the relationship, if that's how she made the design, then it answers the questions not only about qualification, but also about ownership. So if she didn't make the design in the course of her employment, because she was a placement student, and therefore not expected to make designs, she retains design right, but only if she qualifies. She doesn't qualify by nationality, but she might qualify by habitual residence. You'll be getting good marks if you make those points, and if you go on to tell the examiner that as far as what you need to tell Wanda is concerned, you've got to tell her to get an assignment from Ursula, then I think you'll be heading for a first-class mark. What if she's not habitually resident, which we identified was the only way in which she herself could qualify for protection? If qualification depends on first marketing, then the law provides that the employer, Blanc, is going to own design right because it first put the goods on the market. So Ursula's the designer, but she doesn't get to own the rights in the design. So you could be forgiven for thinking that you must be nearly at the end of this question already. But I'm afraid you're not even halfway through. Next, you need to consider what design right protects. And here you'll trot out the definition of a design, you'll talk about features of shape or configuration, internal or external of the whole or any part of an article. It doesn't seem to me that you need to worry about the 2014 amendment which took out the words aspect of, and frankly you're not going to have any time to say to the examiner, I don't think I need to consider this. Anyway, you're examined on the law as it exists on somewhere around the 14th of February. So that 2014 amendment is ancient history. So we're looking at designs for an article. Is the dress an article? Highly likely. Are the integral gloves part of the article? I think the word integral rather gives that away. And here's an important point. Are the blowers features of shape or configuration? Because it's only features of shape or configuration that get protection as design. It doesn't matter that they're internal features and therefore they're not visible in normal use. That doesn't affect the scope of design protection, but the fact that they're there to do a job rather than to look any particular way is an important consideration, and I think you need to explain to the examiner that you recognise the possibility that the blowers are not going to be covered by design protection at all, nor indeed by copyright. Then you've got the embroidery, and the question there is whether this is going to be capable of being protected by design right or whether it is excluded surface decoration. So having considered the scope of what is actually a design, the next question is to consider whether the design is original, because designs are only protected if they are original. So tell the examiner that the test for originality, the courts say, is the same as in copyright, or at least it's much the same. It's got one specific difference, which we'll come to in a second. That is that for design right purposes, a design won't be considered to be original if it's commonplace. We'll look at that a little bit later, because I think that the logical way to approach this is to say to the examiner, well, the test for originality is pretty much the same in part 1 and part 3, so let's deal with originality for purposes of both these rights together later. I told you that I thought it was best to keep design right and copyright separate, but I think this is the point where it makes much more sense to bring them back together again. Otherwise you'll end up writing the same stuff twice, which is not a good idea in any exam. The duration of design right, and indeed of copyright as well, is not an issue in this question, but I think it's worth letting the examiner know that you're familiar with the term of protection, and make the point that the articles made to the design were first made available for sale only last year, so protection has still got plenty of time to run. Another 9 years from the date on which they were made available for sale. And I think don't bother telling the examiner anything more about the rules about the term of protection, because you simply haven't got time. You've got to get on and consider what copyright protection there is. And here you could start with looking at the qualification rules, but I think it's probably more productive to identify the copyright works, and usually in copyright problem questions that's where you're going to have to start. Never lose sight of the requirement for qualification, but usually identifying what the works are is an important starting point. That might lead you to consider who the authors or prospective authors are, and then you can think about qualification. Here it's a bit easier, although it's still not entirely simple. So what copyright works are there? Well, Ursula made sketches. Sketches are artistic works. They're protected irrespective of artistic quality. The big issue about them is going to be originality. The dress may be a work of artistic craftsmanship. The fact that it was handmade is a bit of a, as I said earlier, a signpost pointing to this as a possibility. Vermaat and Boncrest tells us that a work of artistic craftsmanship can have an artistic creator and a craftsman or woman involved in the making, and that seems to be what we've got here. Do by all means tell the examiner that you remember the case of Burke against Spicer, where the court held that a beautiful frock was not a work of artistic craftsmanship, but add that this was in 1936 and the world is a very different place and copyright law is a very different law. Well, you don't need to say that. I think you just need to mention the age of the case. And although there aren't any more recent cases involving beautiful frocks, the law has developed in a way which might be a little more helpful in this particular case. Copyright protection is also going to be relevant to the embroidery, because the good chance that that's going to be regarded as an artistic work as well, the pattern for it. If there are sketches, then that's great, because it's fairly clear that the sketches are going to be a copyright artistic work. Mention qualification, the copyright rules are very different from design right rules, and the Berne Convention means that Ursula is going to have no problem being recognised in her own right as being entitled to copyright protection. Slight complication here that Ursula and Victor are going to be joint authors of a work of artistic craftsmanship, or it looks as if they're going to be, but you're not advising them. That's going to be an ownership issue. So if they're joint authors and joint owners of copyright, then you're still going to be telling Wanda that she's got to get some assignments in order to collect up the rights that she needs to sue. Although there's a possibility that Blanc Ltd already owns the rights that it needs. Let's look at the sketches first. If Ursula created the sketches in the course of employment, then the employer owns the copyright. As we've already seen, the facts make that seem unlikely. But the way to getting maximum marks is to mention both the possibilities in a situation like this. What about the work of artistic craftsmanship? Victor was employed as a pattern cutter, so whatever he's contributed to making the work of artistic craftsmanship, the copyright in what he did is going to vest in Blanc Ltd automatically, and Ursula's interest in the copyright is going to depend on her employment status. Your advice to Wanda, I think, is to say that Blanc Ltd probably needs to get an assignment, certainly from Ursula, probably also from Victor just in case, even if it's only expressed to be a confirmatory assignment. I mean, basically a legal document which says the parties believe that all the rights have already gone to Blanc Ltd, but in case any rights still remain with them, they're assigning them over. I don't know whether the examiner had in mind that you would go into that level of detail, and it's more a point that you would expect in professional exams than in undergraduate exams, but I hope it's exactly the sort of thing that would really impress the examiner. The duration of copyright isn't an issue in this question, but again I think it's a good idea to ensure that the examiner appreciates that you realise what the situation is. So copyright's going to last for the life of the author. That's Ursula, to some extent it's Victor, plus 70 years. And also the ownership of the copyright doesn't affect the duration of the copyright. So even if they were both considered to be employees and Blanc Ltd owned the copyright right from the start, the duration of copyright is still going to depend on Ursula's and Victor's lifetimes. So now we've identified what rights there might be and who might own them. The next stage is to apply to both design right and copyright the originality test. Copyright works are protected if they're original, designs are protected if they're original. The courts have said that original means the same in both systems, thank goodness. And for the purposes of copyright and design right, the fact that Ursula made the sketches from an old painting indicates a severe lack of originality, even if you're applying the traditional UK originality test and saying, was it her work or did she copy it from somewhere else? Well, it looks as if she did pretty well copy it from somewhere else. You don't even have to think about InfoPack and the Euro originality test, which has become important in the copyright world. What we don't know is what elements of the dress design she copied. So if it was only the overall shape, then perhaps the embroidery, perhaps the integral gloves remain original. The inclusion of the blowers is no doubt original in a sense, because she dreamt that up, but it's not something that either copyright or design right is going to give any protection to anyway. Design right rules have got this added requirement that the design not be commonplace, because if it is commonplace it won't be regarded as being original. There's nothing in the question to make you think that it might be commonplace. So if you can make a little bit of time for this, it's worth telling the examiner that you realise that this is part of the design right test, it's not part of the copyright originality test. You don't need, I don't think, to go into the farmer build case in detail. and set out the criteria laid down by the Court of Appeal. But if you can convey to the examiner the idea that unless there are a lot of similar looking dresses on the market, not including those made by Noir and Gris, then commonplace isn't going to be a problem for this design. Next, you've got to consider whether the design right has been infringed. State the test for infringement. Infringement by making, that's what's gone on here. It's not as if the designs themselves have been copied, in terms of the design on a piece of paper. The design has been copied by Noir and Gris making dresses, articles exactly or substantially to the design. That's the test of whether an infringement's taking place. You need to consider the treatment of the excluded elements, embroidery in particular. That's surface decoration, that's excluded from protection, so that's not included in the infringement equation. What about the blowers? They really irritate me, these blowers. They're not clearly one thing or another. Arguably they don't form part of the design, and I think that's the way that you've got to deal with these. They're not features of shape or configuration, or rather say they don't seem to be. Don't be too dogmatic about it, because you should also say to the examiner, however, if that's not right, if they are features of shape or configuration, the fact that you can't see them doesn't make any difference. Then deal with infringement of copyright. Again, state what the test is. Reproducing, etc., the whole or a substantial part of the copyright work. The main act that may have been carried out here is reproducing, but distribution to the public may also be relevant. I've often seen students get bogged down in discussions about secondary infringements, but here you're told nothing about secondary infringements in the question. No doubt there are going to be some people somewhere committing secondary infringement, retailers who are selling on the products made by Gris and Noir, but since they're not in the question, they shouldn't be in your answer. And it's very rare to find the examiner asking questions about secondary infringements. So when you consider infringements, you also need to consider defences, and section 51 is what the examiner wants to read about here. You really need to be able to explain section 51 without having to stop and think about it. The section 51 applies if the copyright work involved is a design document. So here it's Ursula's sketches. Insofar as the dress is a work of artistic craftsmanship, it stands and falls on its own. So we're only considering section 51 in the context of the sketches. Are they design documents? What was the creator intending to do? When Ursula made those sketches, did she think she was designing a dress, or did she think she was making some sort of artistic work, even if it was a copy of an earlier one? Well, here it's not entirely clear what she was doing, or what was going on in her head. So they might be design documents, they might not be. If they are design documents, the next question is, do they depict an artistic work? And this is where the possibility that the dress is a work of artistic craftsmanship becomes particularly important. If it is a work of artistic craftsmanship, that means copyright in the sketches is not affected by section 51. It remains enforceable. And copyright in those sketches can be infringed by making the dress, even though the infringement is indirect. The infringer never saw the drawings, the infringer worked from seeing the dress on TV, for example, would still make it an infringement. And that's the importance of section 51. So, to conclude, I'd say there's a great deal in this question, and there's a great deal in all design problem questions that I've seen in these exams. So that makes it particularly important to be organised. Approach the questions systematically, and you'll be okay. Resist the temptation to write too much on any one topic, because you've got a lot of ground to cover, you've got to ration the time. Pace yourself. Remember that copyright and design right will both be in the question. I'm not going to guarantee that absolutely, but it's almost guaranteed. It's also almost guaranteed that the article in the question is at least possibly a work of artistic craftsmanship, so that you'll be able to say section 51 wouldn't apply if it is. But these questions are always going to have copyright and design right in them. Copyright side of it will have a work of artistic craftsmanship, and you'll have to discuss section 51. Finally, look carefully at the dates. In this question they didn't reveal anything particularly. Nationalities, Ursula was American. Residence, the fact that she might well have lived in London could have meant that she had design right in her designs. Well, I rather like these design questions. I've seen a lot of them over the years, and it's very helpful to you in preparing for the exam to know that the examiner works very much to a formula with these. So it's not entirely predictable what's going to come up in the questions, but certainly there's a great deal of continuity and a lot of themes that you find running through all of them. So if you get a question like that in your exam, and I think there's a strong chance you will, good luck with it. I think you've got everything there that you can possibly need to answer the question. If you found this talk helpful, I'd be really grateful if you'd give it a like on YouTube, and I'd be even more delighted if you would subscribe to the channel, and then you'll get new lectures as and when I record them. You can also leave your comments, and I'd be very interested to read comments if anybody has any to make. They could help me to ensure that future presentations are better than this. Thanks very much for listening. Good luck with your exams. I'll speak to you again soon.